So, what happens when something as simple as a loan dispute turns into a weapon? We're about to dive into a landmark case from India's Supreme Court that starts with just a few missed payments, but ends up completely rewriting the rules on how criminal complaints are filed. It's a fascinating story of how the legal system itself got twisted in a way nobody saw coming.
I mean, think about it. If you miss a few loan payments, you'd probably expect some calls from the bank, right? Maybe a lawsuit. But would you ever expect to see the bank's top officials facing criminal charges over it? It sounds almost unbelievable, but this exact scenario is what sparked a legal firestorm that went all the way to the top. And that, right there, is the heart of this whole thing. You know, the law is supposed to be a shield, something that protects people. But what happens when that shield gets reforged into a sword? When it's used not for justice, but for pure intimidation?
Okay, so let's break down how this all started. It began as a completely routine financial issue, but it was about to take a very sharp, very unexpected turn into criminal territory.
So picture this. It all begins simply enough. A housing loan gets taken out back in 2001. A few years go by, and by 2007, the borrower has defaulted on the payments. The bank does exactly what you'd expect. They follow the standard procedure, declare the loan a non-performing asset, an NPA, and start the recovery process. At this point, it is a purely civil matter, textbook stuff.
Now, what's really important to know here is that there's a specific law designed for this exact situation. It's called the SARFAESI Act. It basically gives banks a clear civil pathway to get their money back without having to immediately clog up the courts. This is the established, by-the-book way to handle things.
But that is not what happened here. Nope. The borrower completely sidestepped the civil process and took this extraordinary leap. They filed a criminal complaint against the bank's top executives. All of a sudden, this wasn't about money anymore. This was about the threat of arrest, of jail time.
So you have to ask, why? What was the end game here? Well, the Supreme Court itself later described the strategy perfectly. This criminal complaint wasn't actually about getting justice, it was a pressure tactic, pure and simple. The real goal was to scare the bank's employees so badly that they'd accept a lowball settlement offer they would have never considered otherwise.
And this one complaint didn't just go away. It kicked off a legal battle that dragged on for years, escalating from one court to the next. Let's take a look at how this whole journey unfolded.
And believe me, this was a marathon, not a sprint. The loan was from 2001. The legal fight doesn't even kick off until 2007, and for the next 5 years, the case just bounces around the lower courts. It gets dismissed by a magistrate, then nope, it's revived on appeal. It was this total war of attrition, until finally, in 2012, the bank officials decided enough was enough. The only way to end this was to appeal to the Supreme Court itself.
And this is where things get really interesting, because the Supreme Court didn't just look at the details of this one case. They saw a much bigger, systemic problem and started asking some really fundamental questions about how the law was being used.
At the center of all this is a legal tool called Section 156.3 of the Criminal Procedure Code. Now, what this lets you do is go directly to a magistrate and ask them to order the police to start an investigation. It's an incredibly powerful tool, and the court wanted to know, was it being used correctly?
So the first big question was all about judicial responsibility. When a magistrate gets one of these requests, can they just rubber stamp it and pass it along to the police? Or do they have a duty to actually look at the complaint, to really examine it, and decide if it has any merit before kicking the entire criminal justice machine into gear?
Next, they wondered about the proper order of things. I mean, usually, if you have a criminal complaint, your first stop is the police station, right? The court questioned whether it was okay for people to just bypass the police entirely and go straight to a judge. Shouldn't there be a clear first step you have to take?
And finally, maybe the most important question of all was about accountability. Should you be able to file a complaint that could potentially ruin someone's life and career without having to take any personal responsibility for whether your claims are actually true? The court seriously considered if people should have to file a sworn affidavit, basically putting them at risk of perjury if they're caught lying.
Answering these questions led the Supreme Court to do something pretty profound. They didn't just rule on this one loan case. They actually created new rules, new safeguards for the entire country to stop this kind of abuse from happening ever again. So, here's the new playbook they laid out, a clear, mandatory sequence. The logic is simple. First, you have to go to the police. They're the primary investigators. And if they don't do anything, you have to escalate it with a senior police officer. Only after you've tried that route can you go to a magistrate. This creates a firewall. And that final step, the sworn affidavit, makes sure that by the time a complaint hits a judge's desk, it comes with real accountability attached.
You can really feel the court's frustration in this quote from the judgment. They were essentially saying, all right, enough is enough. From this moment on, if you want to use this powerful legal tool, you have to stand behind your words, and you have to do it under oath.
So what's the big deal with this one document, this affidavit? Well, it fundamentally changes the whole dynamic. It forces someone to stop and really think about what they're alleging, because now they face the very real risk of perjury if they lie. This gives a magistrate a real basis for scrutiny, and it acts as a powerful filter, weeding out those malicious or just plain frivolous claims before they can do any damage.
And this brings us to the legacy of this case, because this wasn't just another judgment that gets filed away. Its impact has been incredibly profound and permanent.
Here's the single most important thing to take away from this. The rules that came out of this case, which is famously known as the Priyanka Srivastava case, weren't just some friendly advice. They became binding law for every single court in the country, and they changed the entire legal landscape almost overnight.
But the story doesn't even end there. Get this. The ruling was so important, so influential, that years later, when India was drafting a whole new criminal code, this judge-made rule was written directly into the law itself. What started as a safeguard created by the court has now been permanently cemented as the law of the land.
So at the end of the day, what this case really did was rebalance the scales. It put up some much-needed guardrails to make sure that access to justice doesn't become a free-for-all for people who just want to use the system to harass others. It built a wall to protect the integrity of the legal process itself. And that leaves us with one final thought-provoking question to chew on. These new rules are clearly designed to be a shield, to protect innocent people from false accusations. But by adding more steps and more requirements, do they also become a hurdle for genuine victims, for people with legitimate grievances who are trying to get justice? It's a really delicate balance, and it's pretty much the central challenge in creating any fair legal system.